At your pretrial deposition, I tell you you have to answer the question. You turn around and say, I'm not answering that question. What happens next? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a beautiful day today here in Great Neck, and I want to share this really useful information with you. Okay, you've decided to bring a lawsuit. Maybe it's against a careless driver. Maybe it's against your careless doctor, and you suffered significant harm and injury. And now, during the course of your lawsuit, the attorneys who represent the people whom you have sued will have an opportunity to question you in a process called a deposition. That's nothing more than a question and answer session that's given under oath, and it takes place in our office, in our conference room to be exact. And guess what? There's no judge there, there's no jury there, but there is a court stenographer there to record all of the questions you are asked and all of the answers that you give. And you should know something really important. All of the answers that you give during this question and answer session represent your sworn pre-trial testimony. And by the way, it carries the same exact weight as if you are testifying at the time of trial. So now, during the course of questioning, the defense attorney asks you a question to which you simply don't want to answer. The defense attorney asks you a question to which you are outraged, and you turn around and say, I'm not answering that question. That's outrageous. Now, what kind of question might he ask that you might get so incensed and so outraged about? Mr. Jones, how often do you have sex? That could be a question he asks you. And you're turning around saying, why is he asking me that question? Regardless of the why, and I'll explain in a minute why he might be entitled to ask that question, the bigger question is, why aren't you answering the question when I'm telling you that you have to answer the question? Now, that creates a problem. You see, when you bring a lawsuit seeking money as a form of compensation for all of the harms and losses and damages that you suffered, you now basically create an open book to your life, or at least most of your life, as well as the injuries and your medical condition. The defense now has an opportunity to learn from you in your own words exactly what happened, as well as what injuries you suffered because of whatever carelessness was caused by their client, right? So now they're entitled to probe, they're entitled to ask questions. Why might a defense attorney ask how many times you have sex? If you are married, for example, there are many times where your injuries will affect your personal relationship with your spouse, including your sexual relationship, including your intimate relationship. So now the defense has an opportunity to go ahead and find out and learn exactly what problems you have with your spouse. How has your relationship been affected? How many times did you have sex before? How many times are you able to have sex now? And those are permissible questions if there's a claim for loss of services or what we call legally a loss of consortium, which simply means that you bring a claim saying that because of your injuries, now you and your spouse are unable to do the same things you used to do before you suffered injury. All right, but let's get back to the more important question. What if you refuse to answer the question? Well, now the defense attorney is going to ask you many other questions along the same lines. And if you still refuse to answer those questions, now it's going to create a standoff, and it's going to create a problem. The defense attorney likely will call the court to ask for an intervention. Say, listen, you've got to tell him to answer the question, the judge will tell us. And I'll say, Judge, I've been telling him that since that happened. Now, the judge has many options available to him if you continue to refuse to answer a proper question. One of which is the judge can actually dismiss your case. Why? Because you are not cooperating and providing the defense an opportunity to learn information from you and to discover the events that transpired because of the carelessness that occurred here. So if you refuse to answer those questions, now you put your lawsuit at risk. There's a potential that now the defense attorney will ask the judge to take action, and the most extreme action is to dismiss your case. Alternatively, the least extreme is to tell you and compel you to go ahead and answer those questions, telling you that it's proper, which I will tell you that it's proper or not proper. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these accident cases, these medical malpractice cases, and these wrongful death cases here in the state of New York. You know, I realize you're likely watching this video because you saw the beautiful greenery and it's beautiful springtime here. No, I know that's not why you're watching. You're watching because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.